We have mother, Ms. Lunsford. We have father, Mr. Nowakowski. We have Ms. Lunsford's attorney, Mark Van Sluten, Ms. Lunsford's guardian ad litem, Stephanie Cardenas. We have father's attorney, Ms. Coletti, child's attorney, Ms. Van Dyken, various agency workers, as well as the CASA.
Mr. Young, what's your role in this case?
I was previously the foster care case manager for the case, but most recently I was promoted to supervisor, so I will be the supervisor on the case.
Okay. You signed a report that was, I assumed it was written by Mr. Dortman because he also signed it. Date of report 10/27/25, is that correct?
Yes.
Quick legal clarity. The court just admitted two key documents as evidence: an agency addendum and the CASA report. That matters because these written records often carry heavy weight. They memorialize appointments kept or missed, services offered, and professional recommendations. Translation. What's in these exhibits can shape the judge's findings on parental compliance and the child's best interests. Pro tip for viewers following family court cases: no objection from counsel signals consensus that the court can consider these documents. Question for you: do you think written records should outweigh live testimony when the two don't perfectly align?
And were you able to review the CASA report of 10/29/25?
Yes, I was.
Your Honor, I'd ask to mark and admit the court addendum of 10/27/25 as Exhibit 1 and the CASA report as Exhibit 2.
Any objection?
No objection. No objection.
All right, it's admitted, or they're admitted.
Thank you. Mr. Young, SN still resides in foster care, correct?
Yes.
And that foster care home is meeting all of her special medical needs at this time?
Yes, they are.
And why don't you tell us a little bit about the needs of SN?
Yes. So SN, when she came into care, she had a TBI, which her further diagnoses resulted in like seizures, a traumatic brain injury with the loss of consciousness and fatal spasms, global development delays, hypotonia, chronic subdural hemorrhage, and then subdural hemorrhage.
She has numerous doctor appointments, correct?
Yes, every week. She has multiple, even sometimes there's sometimes like 2 to 3 in a day. She requires one-on-one care. She recently too has been receiving like special medical equipment through Mary Freebread that she has like standards. She has a special like car seat for herself, along with like a specialized stroller.
With all of those appointments and everything that's going on, is she up to date on her medical?
Yes.
Okay. She just has these ongoing multiple concerns.
Correct.
Okay. And I believe that SN is receiving early on services as well?
Yes, SN, she goes to neurosurgery, neurology, and then neurodevelopment as required. And then she also receives early on services, physical therapy, occupational therapy, and then speech therapy as required.
This is the heart of the case. You're hearing a detailed rundown of SN's diagnoses after a traumatic brain injury: seizures, developmental delays, hypotonia, and ongoing subdural issues, plus an exhausting rotation of specialist visits, sometimes multiple in a single day. The foster placement is meeting medical needs and securing equipment: special car seat, stroller, standers, exactly the level of structure the court wants to see. Here's the legal lens. When a child's needs are this specialized, courts look not just at love and intent, but logistics: who can safely execute care plans, manage therapies, and stay calm during medical escalations. Would you feel ready to take this on without a deep training runway?
Anything about SN that's not contained in your report that the court should be made aware of?
Just most recently, I'll just note that she was just recently sick and broke out in a fever. However, as of yesterday, I received an update from the caregiver about SN, and she is doing so much better. She broke out in a post-viral rash, and it confirmed that she had been fighting a virus that is now exiting her body. The caregiver reported that SN has been sleeping and eating much better and is back to her happy self again.
Notice how even a routine viral illness becomes a case data point. The caregiver communicated promptly, tracked symptoms, and reported improvement. That steady, documented caregiving builds credibility for the placement. In child welfare, consistency is currency. Judges want proof that a caregiver can navigate fevers, rashes, and setbacks without missing therapy or meds. Engagement prompt. If you were evaluating safety and stability, what signals would you look for? Medical follow-through, appointment logs, or caregiver responsiveness?
She's on track, not on track developmentally, but she's on track size and weight, those kind of things.
Correct.
Okay. Let's move on to the parents. Let's start with Miss Lunsford. She was recently released from incarceration, correct?
Correct.
Have you been able to meet with her and get a proposed parent agency treatment plan with services for her?
Yes, I met with her that Monday after she was released from incarceration because she was released on weekend and the agency is not open during the weekend. So I met with her that following Monday. I actually was able to meet with Miss Lunsford at the Women's Resource Center here in Grand Rapids, where they were able to assist her with getting some personal items for herself, along with helping her apply for a government phone, along with helping her apply for food assistance.
What did you lay out and have a discussion with Ms. Lunsford about what her barriers are?
Yes, we discussed that her barriers as of right now is emotional stability, parenting skills, I would say domestic violence too, or domestic relations. But we were able to discuss that, and I let her know that the expectation is with her just being released now and that she is no longer having those charges against her, that she will be expected to complete a psychological evaluation along with her starting in-person parenting times again with SN, that we would be referring her to foster care supportive visitation, along with referring her to a trauma-informed parenting course.
What services are you recommending for her emotional stability and parenting skills?
For emotional stability, I would like for her to complete that psychological evaluation, just so we are able to get a better understanding of what recommendations would be recommended to her. Along with, I would like Ms. Lunsford to be engaged in at least weekly therapy sessions, just so she is able to kind of process the reasons of removal and just kind of work towards having a better understanding for her emotional stability. For parenting skills, I would like Miss Lunsford to complete foster care supportive visitation so they could work with her during her parenting times to just better help her engage with SN, along with just kind of learning what needs are required for SN if being reunified back to either Mr. Nowakowski or Miss Lunsford, along with just completing a trauma-informed parenting course.
We pivot to mom's progress post-incarceration. The agency moved fast. Women's Resource Center for Essentials, phone and food assistance, bus card, and a plan, psychological evaluation, weekly therapy, supported visitation, and trauma-informed parenting. Legally, that's reasonable efforts to reunify, a required showing. But barriers remain: emotional stability, housing, income, and the history of domestic violence. The strategy here is phased. Start therapy now, don't wait on the psych eval. Stabilize logistics so she can attend services consistently. Reaction. This is the tightrope, supporting re-entry while measuring reliability. Viewers, do you think beginning therapy before the eval is the right call to regain momentum?
Well, you mentioned weekly therapy. Can she begin that before the psychological evaluation so we can get a jump start instead of having to wait months?
Yes, that is definitely something that we are looking into. I was just kind of at the time just kind of seeing, I wanted Miss Lunsford just to get adjusted with her being released, and then she moved to Desert, the homeless shelter, along with, I know Miss Lunsford noted that she had some other appointments, which I'm in the process of following up what those appointments are that she's attending. But that is definitely something that we are able to do, as we have been able to provide Miss Lunsford with a bus card, so she is able to have reliable transportation to get to the services.
So you mentioned that she's staying at Degage, so housing is a barrier as well, correct?
Correct.
Employment or income, is that a barrier?
Yes, that is also a barrier.
And what services or what are you going to offer her to address that?
We at this time, I think we will just look into what housing assistance is available to Miss Lunsford to see what we can do to get her out of the homeless shelter. However, I do want to bring it to the court's attention that Miss Lunsford has recently gotten into a new relationship that isn't with Mr. Nowakowski. The agency just learned about this as they both came into the agency on Friday. But due to SN being sick, we weren't able to have a parenting time, but we are in the process of running central registry clearance forms on this new boyfriend of hers. But I do know that I believe she has also been staying with him at a hotel. I just don't know what hotel.
And have you been able to inquire of her about this relationship?
Miss Lunsford doesn't have like appropriate like communication right now, just due to her not having a cell phone. However, we were able to receive the cell phone number of her boyfriend, in which he notified me this morning that this would be the best way to get in communication with her.
You mentioned that domestic violence was a barrier as well, and now she's recently out of incarceration and into a new relationship within a month. What
Correct.
services are you offering for her to address that?
I would just offer to see if we could get a domestic violence course either through Harbor Circle or through the YMCA, just to see if we can address that. I just know that per what Mr. Nowakowski has reported to me, like he unfortunately does not feel safe to be around Miss Lunsford at this time, due to just him stating that feels that he has received threats when she was incarcerated, but we have not been able to determine if that was actual threats coming from Miss Lunsford. However, it just remains a concern at this time, like as you stated, that Miss Lunsford did jump into a relationship quite fast. And I just think that due to all of SN's needs, like that's just not appropriate at this time. However, we are looking to see if this would be an appropriate support person for her at this time, due to her not having.
This part will make a judge sit up. A brand new relationship within a month of release, limited communication, and the agency scrambling to run clearances on the boyfriend. Add in prior domestic violence concerns and reported threats, still unverified, and you get a safety planning red flag. The worker frames it fairly. Minimize risk, identify support, and keep supervision tight while information is gathered. Key legal takeaway: it's not the relationship itself, it's what it means for safety, stability, and focus on SN's care. Audience question: should attendance at medical appointments be a prerequisite before introducing a new partner into the case dynamic?
Many supports.
Do you have a date for her psychological? Has that been approved?
It just recently got approved, so we are in the process of getting it scheduled.
And is Miss Lunsford informed of the numerous appointments for SN that are necessary for her health and well-being?
Yes, every month when all of SN's appointments are scheduled, the caregiver writes down the dates and times for SN's appointments, and we are able to provide a copy to Miss Lunsford along with Mr. Nowakowski. And the expectation is maybe that they can attend like every other appointment, just because I do not want both of them to attend the same one on the same date. So we would just kind of break that up. But at this time, she has not been able to attend any.
Huge compliance marker here. The caregiver provides monthly schedules to both parents and asks for confirmations. The expectation, staggered attendance, is reasonable and child-centered. But we learn mom hasn't attended yet. Courts track this closely. For medically fragile kids, learning the routine, feeding methods, seizure signs, therapy exercises is essential. Think of each appointment as a training session for reunification. If you were the judge, how many missed opportunities would it take before you question a parent's readiness?
And that's important to learn about the care and the needs of SN, correct?
Correct.
Anything else regarding Miss Lunsford at this time?
No, she does visit. She has had 2 visits with SN so far since being released from Kent County Jail. They have gone well. She has requested 2 hours on Friday just due to the fact of how many appointments SN has. So she just feels that it would be easier for her schedule along with SN's appointment schedule to just visit on Fridays for 2 hours from 11 to 1 p.m. So that is what we have been doing. She didn't have a visit last week, but like I said, it was due to SN being sick.
Have you been able to observe the visits?
Yes, I was the one who supervised both of the visits.
And how do those go?
The first one, we just kind of started off. Miss Lunsford didn't hold SN at all. We had SN in her stroller that just kind of supports SN due to her just not being able to kind of hold herself up on her own. So she just interacted with SN while SN was sitting in the stroller. However, the most recent parenting time that she did have, we were able to have Miss Lunsford hold her the whole duration of the 2 hours, and she did really well. She held SN. We were able to feed SN, along with she was able to change SN's diaper. So there was no concerns.
The visit notes matter. First visit. Mom doesn't hold SN. Interacts while SN remains supported in the stroller. Second visit. A clear improvement. Holding for 2 hours. Feeding, diapering, and no concerns. That kind of observed growth under supervision is persuasive evidence of skill building. But remember, the court will also ask, can this performance translate to unsupervised extended care with medical complexity when professionals aren't present? Your take, does steady progress over 2 sessions show enough trajectory, or do you need a longer track record?
Anything else regarding Miss Lunsford at this time?
No.
Let's move on to Mr. Nowakowski. What barriers remain for him for reunification?
Barriers for him would be emotional stability, parenting skills, and just his understanding of being able to ability to respond to Sasha's medical and development needs. He has employment, he has housing. Our biggest concerns is just wanting to get him into therapy along with more of a trauma-informed parenting skills course, along with just attending all of Sasha's medical appointments.
You mentioned that the caregiver provided a month in advance of all the appointments for SN, and they are provided to Mr. Nowakowski, correct?
Yes, the caregiver sends Mr. Nowakowski a text message letting him know of all of the appointments, and will even send up like follow appointments, asking for him to confirm if he can make any of the appointments. He has been provided these for multiple months now, but at this time he has not attended any.
And not one medical appointment.
Correct.
In your report, you requested that he look at his job as employment to perhaps change due to, is it his schedule, or is it, what is the reason for asking him to change his employment?
Yes, so Mr. Nowakowski, he is a truck driver through JB Hunt, which he is always on the go for that job. And sometimes, like, even when he comes for his parenting time on Fridays, like, he's observed to be very tired, just because he hasn't slept yet. So the agency is just wanting for him to just kind of see if he can find more of an appropriate employment, or maybe a daytime job through the same company that maybe he could work 9 to 5 and then still have the nighttime to maybe attend any appointments, or just better communication of what appointments he does think that he could attend.
You mentioned parenting skills. He did complete the foster care supportive visitation, correct?
That is correct.
Okay. And what other services were you looking to enhance his parenting skills?
I think just at this time, just more of a trauma-informed parenting course too. Unfortunately, there wasn't that many recommendations following the foster care supportive visitation. So I just think that an additional trauma-informed parenting course would just benefit him due to the trauma that Sasha experienced before coming into care.
Switching to dad. Strengths, housing, employment, steady provision of supplies, and positive interactions during parenting time. Barriers. Emotional stability. The need for trauma-informed parenting, and, crucially, attendance at SN's medical appointments. The agency suggests shifting to a more predictable shift or role to free time for medical engagement. This is a classic capacity versus availability problem. Judges often ask, if work routinely prevents essential parenting tasks, can adjustments be made? Audience question. Should courts require a formal work accommodation plan when a child has this level of medical need?
You mentioned that emotional stability was another barrier. What services, what is he working on there?
So me and Mr. Nowakowski have had multiple conversations about getting him into therapy. Mr. Nowakowski expressed that virtual therapy would be the best for him at this time, just due to his work schedule. So I was able to create a list of virtual therapy providers for him. I was able to get his insurance from him, but when I tried calling the multiple places, they just indicated that is something that Mr. Nowakowski would have to call and schedule himself, as they would have to schedule an intake appointment before getting him started. But at this time, Mr. Nowakowski hasn't done that, and he has not been engaged in therapy.
A practical snag. Virtual therapy could fit Dad's schedule, but providers require him to initiate intake himself. This is a small procedural step with outsized legal impact. No intake, no therapy, no documented progress. Courts look for self-directed follow-through as a proxy for future reliability. Reaction moment. It's frustrating when logistics, not willingness, cap progress, but responsibility still rests with the parent to take the final step. Be honest. Have you ever let a simple intake task stall a big goal?
And you mentioned that he has parenting time on Fridays. Sometimes he's tired. Other than those types, how does he do parenting SN?
He does really well. I am very impressed with the amount of supplies that he is willing to provide SN. Just most recently, he bought a whole box of diapers for the caregiver for SN. He even bought SN a pack and play for that stays here at the agency, so he has that during his parenting times. He does very well with SN, but like I said, my only biggest concern is just sometimes we do have to step in and just let him know, like, hey, Mr. Nowakowski, like, you do have to like stay awake during these parenting times, just because he is very tired during the parenting time. So there is sometimes that he is observed to falling asleep.
And it's important that he's awake and paying close attention due to the special needs of SN, correct?
Correct.
Would you agree with me that his biggest barrier would be the understanding of the enormous medical needs of SN?
Yes.
Anything else regarding Mr. Nowakowski at this time?
No, not at this time.
What are your recommendations today?
It is respectfully recommended that SN remain a temporary court ward under the direct care and supervision of the Department of Health and Human Services and Wellspring Lutheran Services. SN remains in a licensed foster home. Ms. Lunsford and Mr. Nowakowski benefit and participate in a parent agency treatment plan. Ms. Lunsford's parenting times remain supervised by the agency. Mr. Nowakowski's parenting times remain supervised by the agency, and this matter be reviewed as appropriate.
And due to the length of time that this child has been in care, while I understand mother was incarcerated for a period of that time, do you think a permanency planning hearing might be appropriate at the next review hearing?
Yes.
Thank you. I have nothing further.
The recommendations keep SN under state supervision in a licensed foster home, with both parents continuing services and supervised parenting time. Legally sound given the record so far, but the timer is blinking. The child's been in care since November 24, 2024, and the court is eyeing a permanency planning hearing. Permanency isn't a threat. It's a statutory requirement to prevent drift. If parents can demonstrate consistent therapy, reliable appointment attendance, and safe housing, the path to reunification stays open. Engagement. Which parent currently has the clearer runway to meet the court's expectations?
Thank you. Mr. Van Sluten.
Thank you. Mr. Young, where are SN's medical appointments? Are they here in Grand Rapids or Rockford or outstanding areas or outlying areas?
To my understanding, majority of them are here in Grand Rapids.
Okay. And do you provide, I know you provide bus passes for Miss Lunsford, but would there be sufficient bus passes if she were to go to medical appointments?
Yes, most certainly. And I just asked that for the time being, since Miss Lunsford did not have a phone, I provided the appointments for her still, but due to her not having phone, I just told her it was very important for her to communicate if she was able to make the appointment. So if she came one of the Fridays for the parent time and wanted to come to one of the appointments, then we would make that work. But due to her just now being able to communicate with Miss Lunsford's boyfriend, I think that is definitely something that we can get started.
Okay.
If she does ask to attend one of the appointments, we will make sure that she has the phone address, the phone number address for the appointment, so
Okay.
she can ensure that she can be there. But my only thing is I ask is that the boyfriend do not attend the appointments.
Okay. She's required to have supervised parenting time. Is that an issue if she were to go to medical appointments?
We would probably have a third party present
Okay.
during the appointment just to see kind of how it goes. And as long as they go okay for the first couple and the caregivers were okay, that is something that we would address and we would bring to the court's attention to see if what we have to do for her to attend without the agency present.
You mentioned she's at Degage. Is the agency doing anything to assist with housing?
At this time, we are just looking into housing resources to see what's available for Ms. Lunsford. However, she has reported that she has been doing well at Degage. She has been able to be provided meals there, a bed, so at this time it's not that emergent due to her just having housing for herself at the shelter.
And then how about employment assistance? Is the agency able to assist with that?
Yes, that is something that me and Miss Lunsford discussed, and she let me know that she was going to start looking for employment for herself, and I let her know that if she needed any help, either myself or Mr. Dortman could help her create maybe a resume or a cover letter. And it sounded like the Women's Resource Center was willing to help her as well.
She's been out of jail just a day over a month, correct?
That is correct. She was released on 10-4.
All right, and you're doing the best you can to make sure that we get services in place quickly, correct?
Correct.
Is she complying with your requests so far?
Yes, she has been very pleasant to work with so far.
Okay. I have nothing further, thanks.
Thanks.
Professional wrap-up. Today's record shows SN's complex medical profile is being steadily managed in foster care, with specialized equipment and high appointment volume. Mother is newly released, resourced with transportation and services, showing improvement in visits, but still stabilizing housing and therapy. The new relationship requires careful vetting. Father demonstrates consistent visitation quality and material support, but has not attended medical appointments and hasn't initiated therapy intake, both critical to understanding SN's needs. The court, mindful of the statutory clock, is moving toward a permanency planning hearing and is securing waivers to address it promptly. Key takeaway: in medically complex cases, documented attendance, therapy engagement, and safe, stable supports drive judicial decisions more than intentions.
Ms. Coletti.
Thank you, Your Honor. Mr. Young, is Mr. Novakowski looking for a different job or where he's not an over-the-road trucker?
Yes, Mr. Novakowski did let me know that he was in communication with JB Hunt about a potential opening, but then they just kind of came back and let him know that there wasn't any current opening. So I don't know where the confusion was there, to be honest with you, just because I think Mr. Novakowski was presented that there was an opening for a daytime position. However, when he had the phone call with them, they stated that there was not. So that is something that he is still looking for. That is something that we kind of address every time I do meet with Mr. Novakowski just to get an update. And he just lets me know that he continues looking.
Okay. And the appointments that he's not able to attend, does he text the foster care or the foster care family that he's not able to make that, or check on how the visit, how the appointment goes?
I'm I'm not sure. I know for right now the caregiver has like a group chat between the three of us. And the caregiver, Mr. Novakowski, will ask how SN is doing periodically, and the caregiver is very well at communicating how SN is doing. In regards to the appointments, I am not sure if Mr. Novakowski communicates with the caregiver separately outside of the group chat. But I am sure that the caregiver also provides an update once parenting times happen.
Okay. And so with regard to these appointments, he's not able to make them with his current schedule, correct? They're not available on
Correct.
weekend? Okay. And so with regard to his counseling, would the counseling by Zoom be available on weekends when he's available?
Yes, Mr. Novakowski kind of let me know that that was just the best thing for him, just because there is times that he is able to stop and kind of take a break from his driving within his job, that he would be able to have like a Zoom counseling, like an hour session. So that is what he thought was going to be best for him.
Okay. And so the main thing is you want him to communicate with you and or the foster parents about which visits he can attend? Or
Yes, I think just to generalize, like when the caregiver provides like the month of the appointments, I think that it would be best if we knew a plan, if there was any that he thought that he could potentially come to, and if there is any barriers, just kind of working that through with him. I know there was also discussion, he asked if he could attend virtually for the appointments. However, the caregiver did discuss this with like the service provider and the doctors, and they just let us know that that is something that we could do. But however, they just don't feel that that would really be beneficial to him, as that it would be more important for him to attend in person.
I see. Thank you. No other questions.
Thank you. The court just noticed that this child's been in care since November 24th of 2024. The law does require that we have a permanency planning hearing at least once per year. And so today is November 5th. So my question to everyone is whether the parents are willing to waive notice and we can do a permanency planning hearing today, or whether we need to try to find another date for a permanency planning hearing before November 24th.
Okay. Mr. Novakowski, could you unmute?
Yes, ma'am.
Do you agree to waive notice of the permanency planning hearing for today so that we can discuss permanence for SN?
Yes.
Thank you, Your Honor. We have no objection to waiving notice.
Okay.
Yeah, all right. I would just ask that maybe Miss Cardenas and I go into a quick breakout room with Miss Lunsford, if that's okay.
That's fine.
All right.
We'll take a short recess.